the European Patent Office is not, the term Europe at the moment seems to sort of conjure up images of Brexit terror, which it has done with trademarks.
Oh, yes. Today we are going to be talking about patents with one of our senior patents attorneys and our lovely co-host Sam Jinks. So we get a lot of inquiries about patents here at Pure Ideas, but there can be some confusion around the subject. Could you give us a brief overview of what exactly a patent is, please?
Of course I can. So what is a patent? Well, a patent for an invention is granted by government to the inventor, giving the inventor the right to stop others for a limited period from making, using or selling the invention without their permission. When patent protection is granted, the invention becomes the property of the inventor, which, like any other form of property or business asset, can be bought, sold, rented or hired. Patents are territorial rights. UK patents, for example, give the holder rights in the UK alone and rights to stop others from importing the patented product into the UK. We also deal in patents in, for example, Europe, the US, and we'll perhaps talk about that a bit later on. But let's focus on the UK right now.
That's all very interesting. So say you've got a brilliant idea, but at what point does that idea become an invention?
So when you've taken that concept or idea and turned it into something that works, or indeed theoretically works, that's the sort of point at which you want to start thinking about patent protection for it. You've got to, when drafting a patent application, we have to just describe the invention in a way that is clear and that the skilled person that we mentioned before could understand. So someone with the relevant technical skill could read the document and carry out the invention. And that's kind of what a patent is about, really. It's about sharing your discoveries and knowledge with the public in exchange for a 20-year monopoly for you to carry out that invention without anybody else muscling in.
That all makes sense. And I bet you get asked this question a lot, but what is the process of actually filing a patent?
So, once you've reduced your concept or idea to practice, you would get in touch with a patent attorney such as myself or one of my colleagues and explain to us what it is that you have invented. And then we would go through a process that's termed drafting. That's where we turn the description of your invention into a document which describes in great technical detail what it is you've come up with. A patent application document is divided into sort of three main sections, 4 if you count the abstract. The first being the description, so that's the detailed description of the invention. Then a set of claims which define the monopoly for which you seek for your invention. Your claims define the features of the invention that you want to protect, you want to have a monopoly over. And then some figures which generally, in terms of mechanical inventions, they're generally schematic drawings or representations. And for methods or processes, perhaps flowcharts or something like that. And then an abstract which gives a sort of a brief summary of what's in the patent document. The main drafting is the description, and then the key part being the claims. So we would draft that, we would agree the content with you, and at that point we would seek to make a filing at a patent office, in this case the UK Intellectual Property Office, and that is the sort of start of the formal process. This gets you your filing date. So the date on which your application is filed is the date at which nominally your protection starts. Once you filed it, then you make some formal requests, those being requests for search and examination. And sometimes actually before we get involved in the drafting process, we might do what's known as a background search to see whether what you've come up with is the subject of pre-existing patent applications, granted patents, or indeed the internet is alive with descriptions of people trying to solve the same problem.
Wow, that all sounds very technical. So everything has been submitted, the fees have been paid. Can you tell us a little bit more about the search and examination phase, please?
Of course. So search and examination are two mostly separate phases of the patent prosecution process. The search is to establish whether there are any documents that includes technology similar to that which forms the subject of the patent application. In the UK, there's often not an opinion accompanying the search report, so it will just be a list of documents and which parts of those documents the examiner thinks are relevant and why. And then the other phase is examination. Examinations are arguably more formal. It is a much more sort of to and fro process. You get a formal examination report, or sometimes a combined search and examination report from the UK IPO, which means that you get your search report and the examination report in one document. The examination report will break down the examiner's objections, if they have any, and talk about why they perhaps think that your claims lack novelty or inventive step. You or your attorney would craft a response to the examination report which would address the examiner's concerns and potentially make some amendments to the claims as well. And you would submit this to the office and either hopefully get a notification that your patent application is in order for grant, or a further examination report with further objections which you might need to address. And this process repeats until you reach a resolution, or in rare cases where you have to attend a hearing to discuss in person or by video or telephone, more likely these days, the objections the examiner might still have. And then once you've completed examination, you have your application in order for grant. Formal things need to be taken care of, but that's really a sort of whistle-stop tour of the process up towards grant.
Amazing. So how long does that all take? What kind of time frame are we looking at?
So generally, you won't see an examination report for a little while after you filed your application. You would often see the search report first, and that might arrive some 6 months after you file the application, could take some months longer. An examination report would probably come 12 to 18 months afterwards, possibly 2 years. It depends these days on how busy the intellectual property office is, and sometimes how complicated the technology is in your patent application. An examination report is accompanied with a deadline for response. Assuming you meet that deadline, you'll hear back. The process, really, getting a patent granted, you're not going to manage in fewer than 21 months, but we're probably looking at 2 to 3 years to get a granted patent. In any event, in the UK, we're bound by what's known as the Rule 30 or compliance period, which runs from 4.5 years from filing, or for 12 months from the first examination report, by which time you have to get your application in order. So it's time limited that way anyway. You can extend that process. We often do, but that's what we aim for, really. So you're probably looking at about 4 years to get a granted patent.
Wow, that's a really long time to get through. That's a lot in comparison to trademarks. So once your patent is ready for grant, what happens next?
Okay, so there are, in the UK, little to do other than pay renewal fees when they're due. This differs slightly in other places. Europe, for example, there's a formal grant process that one must go through, including filing translations of the claims. So 18 months after you file your application publishes. For the first 18 months of the life of a patent application, the content remains confidential. It's not available for public inspection, and these are referred to as unpublished patent applications. And that first 18 months is what sets various deadlines for aspects of the process. So you make a filing safe in the knowledge that what you're developing at that time nobody else can see, but the time you have available to make decisions about where you want to perhaps protect your invention overseas. You make an application for the same content, invention, the same document basically. Within that 12 months, you're able to claim back that original filing date. And this is useful because it means that you don't have to make filings all over the world on day one. You have some time to think, develop, and do all the things that you need to. Danny was gesturing there, make some money, which is important because when you get to the sort of realms of overseas patent applications, they're not cheap. And one of the things that we would perhaps do as well is give the application a tune-up at the end of that 12-month period, adding any new bits and pieces that you may have come up with, which would be subject to a new filing date. The whole point of priority is the subject matter that is filed on day one is always awarded that particular filing date. New material that gets added would be awarded a new filing date. One of the things that is important to note actually with patent applications is once you've made your application, the content of the application can't be added to. It's set in stone from the filing date, so you need to make sure that the content is right from day one. At the end of the priority year, you might add some developments and make these part of your new overseas applications. And two of the territories we're often dealing with are Europe and the US. The European Patent Office is not, the term Europe at the moment seems to sort of conjure up images of Brexit terror, which it has done with trademarks.
Oh, yes.
But in the patent world, this is rather different. The European Patent Office is not part of the European Union. It's its own, what we refer to as a super-European organisation. So that's Brexit-proof. Don't worry about that. Yeah, that's about the size of it. All sounds very simple, doesn't it?
So once your patent has granted, what does that then mean?
That means that you have your registered right in place. That means that your protection for that invention is formalised. You are able to enforce that patent against people who are infringing. Infringing is as we talked about at the beginning, making, using, offering for sale, that kind of thing, the product or process you have your granted patent for. That means if someone was infringing the claims of your patent before the case was granted, this is the date at which, the grant date is the date at which you can take action against them.
Very simple. I can see why people need advice from a patent attorney, but thank you for giving us a great insight into patents. If you have any questions or would like any follow-up in regards to patents or any IP advice, please contact us at Pure Ideas. And if not, we'll see you in the next episode.